Welcome to the INSOL Europe Country Coordinators Coffee Breaks, which we are now doing with, in this situation of COVID-19 confinement. Today is the time for Portugal. My name is Alberto Núñez-Lagos, and I'm the country coordinator for Portugal. But the important participants in today's coffee break are Dr. Fernando Taínhas and Dr. David Sequeira Dinis. I'm going to let them present themselves. And first, I'm going to thank to Ria Menendez, technical team, for helping us in INSOL Europe to organize this event. Please, David, can you take now the word and continue with the meeting?
Hi everyone, this is David from Uria. Most of you probably know me by now from Portugal. I'm this head of the restructuring department in Portugal. I tend to work hard on special situations, restructuring, litigation, out of court, in court, and actually have try to bring my expertise and experience also to several courses in law school, both in Coimbra, in Lisboa, in the universities in Portugal, to share my experience with students here. We are very fortunate to have also Mr. Fernando Taínhas, to whom I will pass the floor right now.
Hello, my name is Fernando Taínhas. I am Portuguese. I am a Portuguese judge. I'm at the Lisbon Commercial Court since 2014, and since November 2019, I am also a legal advisor to the Ministry of Justice here in Portugal. So I am doing this work regarding special civil and commercial law, trying to draft legislation and give opinions and to help to make these matters forward here in Portugal, trying to do my best also in the government.
Thank you very much to both of you. If you allow me, I'm going to start today's discussion with a question to both of you, first to Dr. Fernando and then to Dr. David, but the same question. As you know, there are member states which have already implemented or are almost there to implement the preventive restructuring framework directive. The idea of these member states, for instance, Germany, is that the crisis is going to hit so hard the European businesses that the best way to try to get out of this crisis after the exceptional measures agreed for COVID, like moratoriums or like insolvency holidays, when these measures cease to have effect, and companies try to go back to normal, it is expected that we will have a lot of insolvencies due to illiquidity and also due to accumulated losses for low activity during all these almost 2 years, which is going to be the case. In this scenario, there are, as I was mentioning before, there are countries like Germany who consider that to have this restructuring implemented in national legislation will be a very important tool to be used in order to soften the effects of the insolvency situations which may come. What do you think is the situation going to be in Portugal? Which is the status of the implementation of the directive in Portugal, and which are the current tools of preventive restructuring in Portugal, which may be used, and how they're going to be used when these moratoriums and insolvency holidays cease to have effect? Fernando, if you could address this issue before first.
Thank you. Thank you for your question. I think, to my knowledge, Portugal requested an extension of the deadline for transposing the insolvency directive. That's not. It was not only Portugal, because other countries like Bulgaria, Greece, Slovakia, Estonia, Croatia, the Netherlands also have done so. In Portugal, the main reason I think that was behind this decision was the fact that here in Portugal we have several instruments that can respond efficiently to the needs that we're going to have afterwards the moratoriums ended. So I think that we can talk also afterwards. David and also I myself can say what the instruments that we have. But I think the main reason is that the directive has some challenges regarding the Portuguese legislation, especially the classes of creditors. And so for now, to make a speedy transposition of the directive, I think it was a wiser decision to wait and see what's the impact of the pandemic crisis in the Portuguese economy, and afterwards to assess and evaluate the needs that the insolvency code must have with the amendments regarding not only the transposition but the impact that the economic crisis will have. Now, as you know, we are now having a general containment, a severe general containment here in Portugal because of the sanitary situation. So we have to. We don't know what's going to be the impact in our economy, because, as you know, also Portugal, most of our economy is based on tourism, and so the pandemic doesn't facilitate tourism. But I also hear David's opinion regarding this.
Well, first of all, I would like to take this opportunity to start by saying something that I do believe is fair, which is to thank we have here a judge, and I would like to thank publicly the work that the magistrates have been doing during this crisis. It would be very easy for them, especially in the commercial courts, to just lay back and enjoy this kind of vacation, the lockdown vacation, which was not the case. And they really helped making all cases move forward in a very tough time. And this is important to say, because the best resource that we have against this crisis is the correct interpretation of the law. Obviously, we do need to have a lot of, it's like Batman. We have a utility belt, and we need to use specific devices, gadgets to fight crime. But the fact is, if you don't have Batman and only have the utility belt, it will not work. This is kind of a very not so funny analogy to what's happening. So first of all, thank you for that, to all of you. Second point that is important to highlight is the fact that the government took a very wise decision in postponing the transposition of the directive to Portugal. Because in fact, there's a very good Roman law principle, which is you don't take decisions in times of crisis. And taking a very important decision, because as you know, the restructuring directive includes a lot of opt-ins, opt-outs. So it's not, there's a lot of macro principles, but that can be changed, nuanced, amended in light of opt-in, opt-out micro decisions. And this was not the time to take a heated decision on this. So also agree with this view that was just laid down. And actually the government also understood that something needed to be done to tackle, well, tackle is a strong word, but try to cope with this crisis that we're facing. And as I'm sure it will be Alberto's next question, because I can read it in his eyes, we will be discussing each one of those. So thank you.
So thank you. I was muted, sorry. So David, continue with the question I'm making you.
Well, I will. So at this point, as you know, and we, well, most of them, better than me explaining that, I will then address forward this question to Mr. Fernando Taínhas. But the point here to me is that we had two big changes in Portuguese law. One was, in my view, a new schemes of arrangement, exceptional, temporary, similar to pre-PAX. A lot of people has criticized the measure, saying that it's almost the same that we had before. One of those gadgets that we had, one of those tools that we had in the utility belt was not really being used. I will leave this as a question to Mr. Fernando Taínhas to take a stand. My view is that it's very welcome to have another gadget. Batman always enjoys having another gadget there. And secondly, the second point that I wanted to make is we also have something that is very important, which is a new framework to speed the distribution of proceeds in insolvency. So this is massive. I've heard multiple numbers saying that we're 2 billion, 5 billion euros of money or slash value stuck in Portuguese courts. I do know for experience that that's a lot, that at least a lot of money is stuck there. And amending the law to speed the distribution of these proceeds is very important because it brings liquidity to companies. It also helps the effort of the Portuguese banks selling their NPL portfolios, because it basically increases the value of the NPL, because liquidity, it's not 10 years down the road, it's just around the corner. And that helps banks. By helping banks, we're helping Portugal. But please do, Mr. Fernando Taínhas, we're here to hear you.
Thank you. As you said, well, first of all, Portugal in the summer after the first containment, the Portuguese government approved an economic and social stabilization program, and within this program there were approved some measures regarding the maintenance of employment, like the speedy layoff mechanism. We have into force moratoriums that will end. For now, I don't know if they are going to be extended, because we are now dealing with a new containment, and well, this changes every week, I may say, if I may say so. And so this will end in the 31st of March. But as David said, I think that the main changes, the most important measures were approved within the law 17.5 to 2020, that was published on the 27th of November, and the creation of a new procedure that we here in Portugal we called PEV. This is extraordinary viability process for companies, and this PEV is a new recovery procedure that it aimed to the companies that were healthy before the crisis, and now they become sick, and so David is right when he says that there was some critics for this new procedure, but I think it has similarities to other procedures, but it has a different goal and a different scope, because it only applies to companies that are in insolvency or pre-insolvency situation due to the economic crisis caused by the COVID, and for that you have to have more assets than liabilities on the 31st of December of 2019. So it's an objective criteria. I think the main difference that this procedure has, it's because they are regarding especially the idea of viability. As Alberto talked at first, the insolvency directive, one of the main issues that it's approached there, it's the viability as the main criteria for recovery of companies. So here in Portugal, this procedure, PEV, as the main characteristic for me, it's that the judge, for the first time here in Portugal, it has to judge the viability of the company provided by the arrangement. I think do not have to evaluate all the business plan, but it has to look to the arrangement and see and watch if it's good to reach the outcome of the recovery of the company. The other part, it's that in insolvency procedures we have a very lengthy procedure, because due to very much causes that I'm not going to bother you explaining, but we have some issues regarding the selling of assets, and so it's not easy. But now this measure, because it has to inject liquidity in economy by making mandatory payments in insolvency procedures that has liquidation proceeds of over 10,000 euros. So this kind of, that's the main issue here in Portugal.
So from what you both are now explaining about the PEV, it seems that the PEV is going to be a very good platform in order to then in the future change to the legislation which will come as a consequence of the transposition of the directive. So it's like Dr. Fernando was saying at the beginning, it's like a pre-test, a pre-model of the implementation of the directive. Would you agree with that?
I agree with that. That's a very good point, because that's what I really think. When the PEV was created, there was two kind of worries regarding the making of the law. Not to create a very different procedure that was going to be very difficult to explain and to implement in the courts, and also with the lawyers and the judicial administrators, and also to embody some kind of spirit of the directive. And the most important spirit of the directive that is embodied in the law 75/2020 regarding PEV is the viability that the judicial administrator must give in 15 days counted from the publication of the agreement, and the part that the judge, for the first time, I think this is very important, because here in Portugal the judge only has to analyze the agreement if he from a legality point of view, and for the benefit of the creditors, if they are not damaged because of the principle par conditio creditorum. So that's the main job for the judge. For the first time, now the judge has to evaluate the viability of for the company that is caused or not caused by the agreement. And so I think this is very important, and it's a new change, an important change that embodies the spirit of the directive. But I also like to think to know what David thinks about this.
Well, thank you. Well, definitely it embodies the logics underlying to the directive. I agree with this. The other people on this panel, they know my opinion by now. I am concerned in the way this is going to be implemented. I believe that we cannot transform the Court of Commerce into a auditing firm to check the viability of the plans. But I also agree that the previous framework in Portugal, where no true check on the viability of the plan was in place, also does not work. So we need to find a middle ground where we do not ask judges to be analysts or financial experts. They do have the ability to ask for help, and they should if necessary. And in a lot of cases, it will be necessary. But I do think that we cannot invade the space where basically Constitution, European law allows the entrepreneur to have its liberty to make the company go ahead, to move forward. Do I follow? So it's difficult to set the boundaries where the judge will trespass into a situation where it should not be in, where it invades the liberty of the entrepreneur, especially when the creditor supported, when the majority of creditors supported. So it's to some extent who is the judge or minority shareholders, because typically these problems will be raised by minority creditors. And so if the majority, the big chunk of creditors want this, the debtor wants this, in my view, the criteria should be the judge should only reject this plan if and when it is apparent, it is obvious, it is flagrant that it is not going to be viable, and or if it is apparent, flagrant, obvious that this scheme is being used to an end which is not really recovering the company. It's to get somewhere, to obtain another goal, which is not exactly this one. So, but this is going to be a challenge, and it will be. It's important to discuss this in these type of forums, and maybe, well, it could always be almost one breakfast only to discuss this, because this is a super material change. And I see, Alberto, I think our time is up, I would say. I would move forward to a summary of what you just discussed. And so, although we are in lockdown, although the world is facing a big challenge, we do have some kind of new tools in our utility belt to face financial distress. We welcome the work that everybody in government, in courts, etc., are doing. And a lot of challenges lay ahead, but I think Portugal is better prepared to tackle them than before. Alberto, back to you.
Thank you to both of you. Again, thank you to Ria Menendez for giving us the technical support. And yes, I agree with you. We will be facing in Portugal, which is a very dynamic country, as it has shown from the last crisis. and we will be able to rebuild the economy because the infrastructure and the assets are there, right? So it's just to restructure in a certain financial and operative way, and going forward from there. So thank you very much, Dr. Fernando. Thank you very much, Dr. David, and let's hope to see us soon.
Thank you.
Bye.
Thank you. Good seeing you. Thank you.